the preceding
case is that the phrase which they have to be used in the complaint is not there in the complaint, the present complaint. That is only sole ground.
Yes, primary ground.
Primary, if that is answered.
Solitary ground. That's answered. I have no case. No, that has not been answered is my reply.
Okay.
And the excessive stress laid upon SP money, Millards, I'll demonstrate. One, it was distinguished by the Honorable Supreme Court. With all due respect, Millards, I would like to politely say this, that I protest with respect to such submissions. Lordship may only take it as a very polite submission of mine. Milord, it's my duty as a lawyer to advance the current existing position of law. When I know, Milord, that this is no longer holding the field, there are instances, Milord, as youngsters, we were told, Milord, that you have to always present the correct position of law and just leave the rest to the court. Because under 226 or read with 482, Lordships also govern the principles of equity. Milord, very well. I'll come to that stage later, Milord, with respect to SP money. But primarily, Milord, I wish to demonstrate the amount of time spent only on the maintainability, which is not necessary for your Lordships to have been taken through all the successive set of judgments. Page 103, internal page 37 of his Lordship's judgment, this objection was raised on maintainability. It was overruled. Milord, may I just request the SLP paper book which was filed, the SLP filed against this Quash petition, Court of Surveyor. So this is the SLP preferred against this Quash petition 845, which was allowed by this Honorable Court and dismissed by the Honorable Supreme Court. May I request page 54. Page 54. May I kindly request, my lords, ground I. Because the High Court failed to consider that identical grounds had already been rejected earlier, rendering the present quashing petition a clear case of forum shopping and abuse of process of law. That's one of the ground raised. Next. May I kindly request page 58. Minutes. May I request paragraph CC. Because the High Court committed a jurisdictional transgression by entertaining a second round of quashing on identical grounds, despite there being no change in circumstances, constitutes abuse of the inherent jurisdiction in the 482, contrary to settled law. This ground was raised. SLP dismissed. But I filed the order of dismissal, my lords, also before this court. That is why the memo dated 16th February 2026. This SLP was dismissed on 13th February 2026.
You might have referred in your synopsis this one.
No, I only principally raised the legal contentions, just to keep it very brief. But the papers are before this court, may I kindly request Court of Surveyor, Quash petition 282 loni memo dated 16th February 2026. Or may I just pass on minutes? I have an additional copy. You want, sir? 16th February. Memo. The maintainability was raised in 845. This Honorable Court negates it, rejects it, allows the petition. Raised as a ground before the Honorable Supreme Court, SLP stands dismissed. May I kindly request for one moment, minutes, memo dated 16th February, just to demonstrate the dismissal of that SLP. in the SLP paper book minutes is page 54 and 58. Lordships are pleased to. This is order dated 13th February 2026. Lordships are pleased to get it minutes.
Yes.
So therefore, my lords, that particular contention stands outrightly rejected. But I'll also demonstrate, my lords, in the why and in what circumstances that contention was rejected. May I just trouble your lordships, my lords, with the paper book in the Quash petition before your lordships, that is 158-36, if that lead petition is before this, before your lordships, my lords. Page number 100 in criminal petition number 158-36.
Petition number
158-36, if that is before, if that is before this court.
Page number?
100 minutes, but relevant page minutes. 100 is the page page number wherein the batch of writ petitions adjudicated by this court commences. May I kindly request minutes the operative portion, page 127. Twice this was read to your lordship's minutes, but the relevant portion went amiss. So therefore, minutes I am required to, or I'm constrained minutes to.
The discharge petition, you can file discharge
My lords,
petition and all.
and may I just request one line, page 128. That's paramount. Page 128. All the grounds, may I read it minutes? All the grounds, including the grounds raised in the present writ, may be raised. That is why my second petition was considered to be maintainable, and two petitions were allowed by this court. Now, my lords, in that bunch of case law, lordships were pleased to refer to the Quash petition 845 starting at 64. May I request the Quash petition at 847 starting at page 1. So this particular page 128 minutes to demonstrate why the second petition is maintainable. It's not. So therefore, my lords, the judgment of Muskan holds the field. That is referred in Quash petition 847. May I just request in the bunch of case law 847, which starts at page 1. My lords, in the bunch of case law, my lords, in the bunch of case law, judgment of 847 is serial number 1. Lordships are pleased to refer to 845 just a few minutes ago. In that same set of papers, my lords, page 1.
Page number?
1.
So memo dated 4/2/2026, but filed in 282 of 2025.
Lordships are pleased to get it, my lords. I'm grateful. In this, my lords, in this judgment, where again this entire labor was laid by the de facto complainant on the maintainability. May I request page 52 minutes. Page 52, para 10. Before adverting to the facts of the case, it's pertinent to note that the petitioner had earlier filed writ petition and batch seeking quashment of the proceedings. Said writ petition was dismissed without entering into the merits of the matter, while granting liberty to the petitioner to approach the learned trial court by way of a discharge, which order was subsequently. At this juncture, it is relevant to observe that the Honorable Constitutional Bench, consisting of 5 judges of the Supreme Court in suo motu, categorically held that 258 has no application to compliance instituted under 138. On that basis, the learned trial court, by impugned order, dismiss the petitioner's discharge petition. In view of the aforesaid facts and circumstances, having regard to the settled legal position laid down by the Honorable Supreme Court in Muskan cited supra, this court is of the considered view that owing to changed circumstances, the present second petition seeking quashment is maintainable. Now, this order, now which stands SL in SLP, it has not been stayed or suspended, which ideally the de facto complaint should have prayed for, but that was rejected. Muskan reference minutes, my judgment, my argument and the contention stands recorded on at page 36.
Yes.
Page 36 minutes, where the paragraph 14 of Muskan Enterprises up to 14 to 20 is referred to, where minutes when a wrong law was applied. Page 37, para 15 is where the court frames that question. Reference is given to SMS Pharma as well. I wouldn't wish to bother your lordships with this paragraph. No? That is settled position of law. So therefore, my lords, with respect to maintainability, twice the de facto complainant had failed. I failed to understand, my lords, why again it was re-urged for such length of time. Nevertheless, my lords, now coming to their second contention with respect to reference of the names. I may have to request your lordships for one moment, my lords, all the three petitions and the complaints enclosed thereunder. If I may start with 158-36, my lords, the complaint is at page number 30. 31 onwards, my lords, is where the contents of the complaint are enclosed or are detailed. Lord, I'll just give a quick reference to the paragraph numbers, my lords. Page 31, paragraph B, small b under numeric 3, facts of the case. It refers to that, my lords, of the accused and the complainant having met and that the accused entered into an MOU. That has no bearing to that of a 138 read with 141. My lords, may I request page 33.
31.
Because 31, my lords, para B. B.
Yes.
Para B refers to, my lords, the complainant averring that the said alleged accused and the complainant have met. Doesn't refer to any check at para B. Refers to their association or say a sort of a connection which the complainant seeks to develop in the form of this complaint. May I also particularly request one particular line, my lords, in the said paragraph B. It's the 8th line. On 28/7/2012, the accused entered into an MOU with the complainant in the capacity of director. Doesn't name anyone. Well, I wouldn't get into the art of English grammar, my lords, whether accused means singular or plural. Now, my lords, may I kindly request page 33. The relevant portion to attract 138 read with 141. Page 33, subparagraph D. The accused came forward, may I read it, my lords? I'm sorry. The third line. The accused came forward and accused 3 issued a check in the capacity of director bearing so and so in favor of the complainant trust towards the partial discharge of the debt due and payable to the complainant trust. While issuing the check, accused 3 filled in all the details except the date of the check. So specifically, it is only accused number 3. The petitioner in this petition, my lords, is the petitioner in 847, which your lordships are pleased to refer. It's a copy paste, the complaints are copy pasted, just that the serial numbers are changed. 847 page 1, sorry, my lords, page 1 of the compilation of judgments. Quash petition number 847 is at serial number 1. The petitioner therein is the petitioner in 158-36.
There he is accused number 2.
There he is added as in a different serial number, my lords, yes. But the contents are copy pasted. They changed the number of Sri Rajshekar, who is the signatory. So the labor of the de facto complaint before this court in this 482 case has been since then till date that you should read the word accused as more than one in number, which is, if I may respectfully submit, is absurd in its first understanding. Goes contrary to the principles of 141 minutes where a specific averment is necessary. Now, minutes in the said compilation, because the compilation is before this court, minutes, may kindly request page number 170. The de facto complaint argument and the council's labor